If someone is charged with an assault, there can be a myriad of defenses. Not only can we hopefully prove that the assault was not intentional, or not serious, or not actually harmful, no injuries occurred. But even if there were slight injuries, even if there was maybe some words that accompanied the assault that made it seem that it was done in an angry, rude, or vengeful manner, there's still a lot of ways that assault charges, especially domestic assault charges, can be negotiated to the person's favor. For instance, let's say the case involves a husband and wife, and for the good of the family, no one wants the guilty party to be punished. A lot of times, I or another lawyer that I work with will represent the opposite side of the dispute. There might be reasons why the alleged victim can assert his or her Fifth Amendment right to remain silent, maybe if they told an untrue story to the police. So sometimes we have another lawyer working with us to get the result. Also, there are things that we can do proactively, because in a domestic situation, what everybody wants is what's best for the family. If the prosecutors know that this is a one-time thing, that the family's going to stay together, that no one was seriously injured, and let's say the defendant has taken some voluntary anger management classes on his own ahead of time, or done some voluntary community service, or gone to individual or family counseling in advance. That's a good way of convincing the prosecutor to do what I call an out-of-the-box disposition. Many people go to court and they say, well, it's my first time being charged with domestic violence. I'll just take the first offender program. It'll eventually be dismissed. While that is true, the arrest itself will stay on your criminal record. It's not eligible for expungement in Virginia. So you will have an arrest for domestic assault on your criminal record, regardless if the end result is a dismissal. Most people will have to explain that to their companies. A lot of companies in the Northern Virginia area, my clients have security clearances. That could be devastating to their career, just getting the charge. So when I say an outside-of-the-box disposition, what I usually try to get the Commonwealth to do is do what's a general continuance. So for 6 months, the matter just stays on the court's docket, but there's nothing in the record that says that my client's entering a plea of guilty. He or she does not enter a plea of guilty. It's just continued generally. We jump through whatever hoops the Commonwealth and I agree to, whether it's go to the anger management counseling is one of the most popular conditions, or the marital counseling or the family counseling. Then we come back in 6 months, and if there have been no further trouble, if the counseling's been completed, then at that point the Commonwealth will move to null pros or not prosecute the charges. That kind of disposition can be expunged in Virginia so that the record of arrest does not show up.